I was backing my snow dump trailer into the driveway when I saw her marching across the street like a woman on a mission. And I knew right then my peaceful Saturday morning was about to go straight to hell. My name is Quincy Xavier, and I had just purchased a brand new snow dump trailer for my landscaping business. Living in Buffalo, New York meant dealing with some serious snowfall every winter, and this trailer was going to be a game changer for my operation. The thing was beautiful. A 12-foot hydraulic dump trailer with DOT registration, proper licensing, and everything needed to haul snow from driveways and parking lots to designated dump sites across the city. I had spent nearly $15,000 on it, and seeing it gleam in my driveway that cold November morning filled me with pride. The woman stomping toward me was Patricia Winters, president of the Meadowbrook Hills Homeowners Association. She was in her mid-50s with that distinctive haircut that seemed to be standard issue for HOA board members everywhere, the kind that said she wanted to speak to the manager before even opening her mouth. Her face was already red, and I could see a clipboard clutched in her hands. "Excuse me," she called out before she even reached my property line. "Excuse me, Mr. Xavier." I stepped down from the trailer hitch and turned to face her, forcing a smile. "Morning, Patricia. Beautiful day, is not it?" "That," she pointed at my trailer with one perfectly manicured finger, "is a commercial vehicle. Section 12.4 of the Meadowbrook Hills HOA covenant clearly states that no commercial vehicles may be parked in residential driveways or visible from the street." I took a deep breath. I had read the HOA covenants when I bought my house 3 years ago, and I knew exactly what Section 12.4 said. "Actually, Patricia, this is a registered highway vehicle. I have the DOT registration right here." I pulled out my phone and opened the photo I had saved of the registration documents. It is licensed for highway use, which means it is classified the same as a regular trailer, no different than if I had a boat trailer or a camper. She barely glanced at my phone. "I do not care what some registration says. It is clearly a commercial dump trailer, and it is not permitted in this neighborhood. You have until Monday to remove it, or you will face fines." "Patricia, with all due respect, the law is pretty clear on this. If it has proper DOT registration and highway licensing, the HOA cannot ban it. That would be like banning someone from parking their work truck in their own driveway." "We absolutely can and do ban work trucks," she shot back. "Frank Morrison down on Oakdale had to park his plumbing van at a storage facility. This is no different. Frank's van did not have personal vehicle registration. This trailer does. There is a legal difference." Her expression hardened. "You will be hearing from our attorney." "Good day, Mr. Xavier." She turned on her heel and marched back across the street to her house. I stood there in my driveway, feeling my blood pressure rise. I had dealt with Patricia before over minor things like the height of my grass being a quarter-inch too tall during a dry spell, or my garbage cans being visible from the street for 20 minutes past the allowed time on trash day. But this felt different. This felt personal. The rest of Saturday passed without incident, though I noticed Patricia walking past my house 3 times, each time slowing down to stare at my trailer and take photos with her phone. Sunday morning, I found a formal notice tucked into my door. The letter, printed on official Meadowbrook Hills HOA letterhead, informed me that I was in violation of Section 12.4 and had until 5 p.m. Monday to remove the offending vehicle or face a fine of $100 per day. I called my lawyer first thing Monday morning. His name was Gerald Peterson, and he had helped me with the closing on my house. I explained the situation while sitting in my home office, watching the snow begin to fall outside my window. "They cannot do this, can they?" I asked. Gerald was quiet for a moment. Well, Quincy, it depends on how the covenant is written. Can you send me a copy of Section 12.4? I pulled up the digital copy of the HOA covenants and read it aloud. Section 12.4 states, no commercial vehicles, including but not limited to delivery trucks, cargo vans marked with business names, or equipment trailers used for business purposes may be parked in driveways or visible from public streets for more than 4 hours within a 24-hour period. And your trailer, it is registered as what exactly? It is DOT registered as a highway trailer. I have a regular vehicle registration for it, same as I would for a car. I pay personal property tax on it. The registration does not say anything about it being commercial only. Gerald hummed thoughtfully. Here is the thing. New York state law generally prevents HOAs from banning legally registered vehicles that are allowed on public roads. If your trailer has proper DOT registration and is licensed for highway use, they are on shaky legal ground. But they can still try to enforce their covenant, which means you might be looking at fines and eventually a lien on your property if this escalates. So, what do I do? Send them a formal letter explaining that the trailer is a legally registered highway vehicle and that New York state law preempts their covenant in this case. Include copies of your registration. I can draft it for you if you want, but it will be cheaper if you just send it yourself. Keep it professional and cite the relevant statute. Which statute is that? New York Vehicle and Traffic Law Section 2102. It deals with what municipalities and private organizations can and cannot regulate regarding registered vehicles. The precedent has generally been that if a vehicle is street legal and properly registered, HOAs cannot ban it outright. I thanked Gerald and spent the next hour drafting a letter to the HOA board. I kept it professional, laying out the facts. My trailer was DOT registered, licensed for highway use, insured and legal to operate on any public road in New York State. I included photographs of the registration, the DOT number clearly visible on the trailer itself, and a copy of the relevant statute Gerald had mentioned. I delivered the letter personally to Patricia's house at 2 p.m. She answered the door in a cream-colored sweater, reading glasses perched on her nose. "Mr. Xavier," she said coldly, "I wanted to give you this in person." I handed her the envelope. "It explains the legal status of my trailer and why I believe the HOA covenant does not apply in this case." She took the envelope like it was contaminated. "The board will review it at our meeting Wednesday night. Until then, the violation stands and the fines begin accruing as of 5 p.m. today. Patricia, I am trying to work with you here. I am not trying to cause problems. I am just trying to run my business and provide for my family. Then you should have considered that before moving into a community with standards." She closed the door in my face. I walked back to my house, anger simmering in my chest. My wife, Rachel, was in the kitchen making dinner. She looked up when I came in. "How did it go?" "About as well as you would expect. She's going to fine me anyway." Rachel sighed. She had never been a fan of the HOA but had agreed to the house because it was in an excellent school district for our 2 kids. "Maybe you should just park it at the shop for now, until this gets sorted out." "It is the principle, Rachel. I have every legal right to park a registered vehicle on my own property. If I back down on this, what is next? They have already sent us violations for the stupidest things. Remember when they threatened to fine us because Emma drew a hopscotch grid with sidewalk chalk? I know. I am just worried this is going to get expensive." She was not wrong to worry. Wednesday evening, I attended the HOA board meeting, held in the community center at the entrance of our subdivision. The room was set up with a long table at the front where Patricia sat flanked by 4 other board members. Thomas Garrett, the vice president, Susan Kimball, the secretary, Robert Chen, the treasurer, and Linda Morrison, a member at large. About 20 other residents filled the folding chairs facing the board. I recognized most of them. The meeting started with standard business, approving minutes from the last meeting, discussing the budget for snow removal on community streets, and debating whether to allow white or warm white Christmas lights on houses this year. Then, Patricia cleared her throat and looked directly at me. Item 7 on the agenda. Violation notice for 847 Maple Ridge Drive, the residence of Quincy Xavier. Mr. Xavier, would you like to address the board? I stood up, my prepared notes in hand. Yes, thank you. As outlined in my letter, my snow dump trailer is a legally registered highway vehicle with proper DOT certification. New York state law prevents HOAs from banning street legal, registered vehicles from private property. I have provided documentation proving my trailer meets all legal requirements. Patricia shuffled some papers. The board has reviewed your letter and your documentation. However, we maintain that Section 12.4 of our covenant applies. Your trailer is clearly used for commercial purposes, regardless of how it is registered. But the registration determines what category the vehicle falls under. You cannot just ignore state law because you do not like what something looks like. Thomas Garrett leaned forward. Mr. Xavier, we appreciate that you are trying to run a business, but this is a residential neighborhood. Our property values depend on maintaining certain standards. If we allow you to park a dump trailer in your driveway, what is next? Cement mixers, excavators. Those would not be street legal or highway registered, I countered. My trailer is no different than someone parking an RV or a boat trailer. Both of those are allowed under the covenant. Susan Kimball spoke up. Actually, Mr. Xavier, RVs and boat trailers are only allowed if they are stored in garages or behind fences where they are not visible from the street. That is not what Section 12.4 says. That is Section 12.6, which deals with recreational vehicles. And even then, it only requires them to be screened if they are stored for more than 72 hours. My trailer is in active use. I am using it almost daily for my business. The back and forth continued for another 15 minutes. Other residents chimed in, some supporting the HOA's position, others questioning whether they were overstepping. Finally, Patricia called for a vote. All in favor of upholding the violation and assessing fines against Mr. Xavier until the trailer is removed from the property, say aye. 4 ayes. Only Robert Chen abstained. The motion carries. Mr. Xavier, you are hereby fined $100 per day starting from Monday at 5 p.m. If the violation is not corrected within 30 days, we will place a lien on your property. I felt my jaw clench. This is not over. You are violating state law and I will fight this. Patricia gave me a thin smile. That is your right, Mr. Xavier. This meeting is adjourned. I left the community center furious. The drive home took less than 2 minutes, but I spent the entire time gripping the steering wheel and trying to calm down. When I pulled into my driveway, the trailer sat there in the glow of my porch light, looking perfectly innocent. The next morning, I called Gerald Peterson again. I explained what had happened at the meeting and asked about my options. They actually voted to fine you, he sounded surprised. Even after you cited the statute. Yes, they do not care. Patricia has it out for me, I swear. Okay, here is what we need to do. We are going to file for a declaratory judgment in court. Basically, we are asking a judge to rule that the HOA covenant does not apply to your trailer because it conflicts with state law. We will also seek an injunction preventing them from assessing fines while the case is pending. How long will that take, realistically? Several months. Maybe 6 to 8 before we get a hearing. But the injunction, we might be able to get that within a few weeks. And how much is this going to cost me? Gerald paused. My retainer for something like this would be $5,000. The total cost depends on how hard they fight it. If they are smart, they will settle once they see we are serious. If they dig in, it could run you $10,000 to $15,000 by the time we are done. I closed my eyes. $15,000 to defend my right to park a legally registered vehicle in my own driveway. It was insane. But what choice did I have? Draw up the papers, I said. Over the next 2 weeks, the fines accumulated. $100 per day added up fast. I kept the trailer in my driveway partly out of principle and partly because I actually needed it for work. November was a busy time for my landscaping business. We were doing end-of-season cleanups, and the trailer was perfect for hauling debris to the dump. The first significant snow was forecast for early December, and I needed to be ready. Patricia seemed to take personal pleasure in documenting my violation. I would see her out in her front yard, photographing my trailer from different angles. She even came onto my property once to take a close-up photo of the DOT number, which I was pretty sure was trespassing, but I did not confront her. I was trying to keep everything above board. The preliminary injunction hearing was scheduled for December 10th. Gerald filed all the necessary paperwork, and the HOA retained their own attorney, a woman named Margaret Sheffield who specialized in HOA law. The day before the hearing, I received a notice that my fines had reached $2,800. The hearing was held at the Erie County Courthouse in downtown Buffalo. I took the day off work and met Gerald in the lobby at 8:30 a.m. We went through security and made our way to the courtroom on the 3rd floor. Judge Harold Morrison presided. He was in his early 60s with gray hair and a no-nonsense demeanor. Margaret Sheffield was already seated at the defendant's table with Patricia and Thomas Garrett beside her. The hearing began with Gerald presenting our argument. He walked the judge through the registration documents, the DOT certification, and the relevant state statutes. He argued that the HOA covenant was in direct conflict with state law and that enforcing it would set a dangerous precedent. Margaret Sheffield countered that HOA covenants were contractual agreements that homeowners entered into voluntarily. She argued that I had agreed to the restrictions when I purchased my home, and that the covenant was designed to protect property values for all residents. Judge Morrison listened carefully, asking questions of both attorneys. Then he turned his attention to the registration documents. Counselor Sheffield, is there any dispute that this trailer is properly registered and licensed for highway use in the state of New York? No, Your Honor. But we would argue that the nature of its use, specifically for commercial dumping, brings it under the purview of the covenant's commercial vehicle restrictions. But the statute Counselor Peterson cited seems pretty clear. If the state has licensed this vehicle for highway use, how can a private HOA override that determination? Margaret Sheffield shifted slightly. Your Honor, the covenant does not ban the vehicle from existing or from being used on highways. It simply restricts where it can be parked within the community. So if Mr. Xavier parked this trailer on the street in front of his house, that would be acceptable. Well, no, Your Honor. The village has ordinances against parking trailers on public streets overnight. So you are saying he cannot park it on his own property, and he cannot park it on the street. Where exactly can he park it? At a commercial storage facility, Your Honor. That is what other residents with commercial vehicles have been required to do. Judge Morrison leaned back in his chair. Here is my concern, Counselor. The state has determined this vehicle is safe and appropriate for highway use. Mr. Xavier pays registration fees and taxes on it. It is his property, and he is parking it on his own property. The HOA covenant may have been intended to prevent unsightly commercial vehicles, but this is not a beat-up work truck. From the photos, it appears to be a well-maintained trailer that happens to be used for business purposes. Many people use their personal vehicles for business. That does not automatically make them commercial vehicles under the law. I felt a surge of hope. The judge continued, I am going to grant the preliminary injunction. The HOA is enjoined from assessing further fines against Mr. Xavier pending the outcome of the declaratory judgment action. However, this is not a final ruling on the merits. We will schedule a full hearing for, let me see, how does February 15th sound? Both attorneys agreed to the date, and just like that, the hearing was over. Gerald shook my hand as we left the courtroom. That went well, he said. Judge Morrison clearly sees the problems with the HOA's position. But it is not over yet. No, but this is a good sign. They are going to have a hard time at the full hearing. I drove home feeling lighter than I had in weeks. The fines had stopped, and I had a fighting chance. When I pulled into my driveway, I looked at the trailer with new appreciation. It was more than just a piece of equipment now. It was a matter of principle. That evening, Rachel and I celebrated with takeout from our favorite Italian restaurant. Our kids, Emma and James, were excited to see me in a good mood. Emma was 8 and James was 6, and they had picked up on the tension over the past few weeks. Did you win, Daddy? Emma asked as we ate. Not yet, sweetheart, but we are getting there. The winter progressed. December brought heavy snow, and my business was busier than ever. The trailer proved its worth time and again, hauling load after load of snow from the parking lots and driveways of my commercial clients. I made sure to keep meticulous records of the trailer's use, sensing that it might be relevant later. Patricia kept up her surveillance. I would catch her watching from her window or taking photos when she thought I was not looking. The rest of the neighborhood seemed divided. Some people agreed with the HOA, worried about precedent and property values. Others thought the whole thing was ridiculous, and told me so in quiet conversations when Patricia was not around. In late January, something unexpected happened. I came home from a long day of snow removal to find a letter taped to my front door. It was not from the HOA. It was from my neighbor directly across the street, a guy named Marcus Flynn, who had lived in the neighborhood for almost 10 years. The letter was handwritten and brief. Quincy, thought you should know. Patricia has been asking neighbors to sign a petition against you. She is claiming your business is bringing down property values. Several people told her no, but I think she got at least 5 or 6 signatures. Just wanted to give you a heads up, Marcus. I showed the letter to Rachel. She is really going all out. What kind of petition? I do not know, but nothing good. I found out 3 days later when Gerald called me. Quincy, the HOA's attorney, just filed a supplemental brief. They are including affidavits from 6 residents claiming that your trailer has negatively impacted the neighborhood and that they have experienced difficulties selling or refinancing their homes because of it. That is complete nonsense. No one on my street has even listed their house for sale in the past year. I know, we will challenge the affidavits, but this shows they are not going to back down easily. They are building a case that the trailer is a genuine nuisance. The February 15th hearing arrived faster than I expected. This time, the courtroom was more crowded. Several of my neighbors attended, including Marcus, who gave me a supportive nod when I walked in. Patricia was there with 3 other board members and 6 residents, who I assumed were the ones who had signed the affidavits. Judge Morrison called the hearing to order, and invited both sides to present their cases. Gerald went first, reiterating our arguments and adding new evidence of the trailer's legitimate highway use and proper registration. He also submitted records showing that property values in Meadowbrook Hills had actually increased over the past year, contradicting the HOA's claims. Then Margaret Sheffield called her witnesses. One by one, the 6 residents testified that the trailer was an eyesore, that it made the neighborhood look commercial, and that they were concerned about property values. Under cross-examination, Gerald got most of them to admit they had never actually experienced any tangible harm, and that Patricia had approached them about signing the affidavits. Patricia herself testified. She was poised and confident, arguing that the HOA had a duty to maintain standards and that allowing commercial equipment would open the floodgates to other violations. Gerald cross-examined her. Mrs. Winters, you stated that Mr. Xavier's trailer is a commercial vehicle, but you acknowledge it has proper DOT registration as a highway trailer, correct? Yes, but that does not change what it is used for. Do you drive a car, Mrs. Winters? Of course. Do you ever use that car to drive to work? Yes. So you use your personal vehicle for commuting to your job. Does that make it a commercial vehicle? Margaret Sheffield objected, and the judge sustained it, but the point was made. The hearing lasted 3 hours. At the end, Judge Morrison said he would take the matter under advisement and issue a written ruling within 30 days. The wait was agonizing. I tried to focus on work and family, but the case was always in the back of my mind. Rachel was supportive but worried about the legal fees. We had already paid Gerald $8,000 and the meter was still running. The ruling came on March 7th, delivered by mail to both parties. I was in my truck when Gerald called. We won, he said simply. I pulled over into a parking lot. What? Judge Morrison ruled in our favor. He found that the HOA covenant is preempted by state law regarding registered highway vehicles. He issued a permanent injunction preventing the HOA from enforcing Section 12.4 against your trailer, and he awarded us attorney's fees. We are getting our legal fees back, most of them. The judge awarded $15,000, which should cover everything and then some. Quincy, this is a complete victory. I sat there in my truck, feeling a wave of relief wash over me. So it is over, as long as they do not appeal. They have 30 days to file a notice of appeal, but frankly, I do not think they will. The judge's ruling was pretty definitive. I called Rachel immediately and told her the news. She actually cried on the phone. That evening, we had a real celebration. I even allowed myself to feel a sense of vindication. But if I thought Patricia was going to let this go quietly, I was wrong. 3 days after the ruling, I found a new violation notice on my door. This one cited Section 8.2 of the Covenant, which dealt with noise ordinances. The notice claimed that I was starting my truck and trailer too early in the morning, creating excessive noise before 7 a.m. I called Gerald. They are harassing me now. This is retaliation. You start your truck before 7 a.m. Sometimes. I have to get to job sites early, especially during snow season. But so do half the people in this neighborhood who commute to work. Keep a log of when you start your truck and when your neighbors start theirs. If they are selectively enforcing the noise ordinance against you, that is going to be a problem for them. I started keeping the log. I also noticed that Patricia's surveillance had intensified. She was documenting everything now, not just the trailer but my comings and goings, when I mowed my lawn, when I took out my trash. It was bordering on obsessive. Then in late March, things took a darker turn. I came home one evening to find that someone had spray painted the word eyesore across the side of my trailer. The paint was black and dripping, clearly done in a hurry. I immediately called the police. An officer named David Ruiz arrived within 20 minutes. I showed him the damage and explained the situation with the HOA. "You have any idea who might have done this?" he asked. "I have suspicions, but no proof. Security cameras. Not on this side of the house." Officer Ruiz took photos and filed a report for vandalism. He said they would increase patrols in the area, but admitted that without evidence, there was not much they could do. The damage cost me $600 to have professionally cleaned and repainted. I was angry, but more than that, I was worried. Vandalism was a serious escalation. This was no longer just about HOA rules and legal arguments. Someone had committed a crime. I installed security cameras the next day, 4 of them, covering every angle of my property. The system recorded to a cloud server, so even if someone damaged the cameras, the footage would be saved. 2 weeks later, the cameras caught something. It was 2 a.m. on a Thursday night when motion sensors activated. I was asleep, but the system sent an alert to my phone. I woke up, grabbed my phone, and watched the live feed. A figure in a dark hoodie was walking up my driveway toward the trailer. They were carrying something, though I could not tell what in the darkness. I sat up in bed, heart pounding. The figure reached the trailer and appeared to be doing something near the tires. I was about to call 911 when I saw another figure emerge from the shadows. This one was also in a hoodie but smaller. They both worked quickly, then hurried back down the driveway and out of camera range. I jumped out of bed and ran downstairs. I turned on the porch light and stepped outside. In the glow of the light, I could see what they had done. All 4 tires on the trailer had been slashed. This time, I did call 911. Officer Ruiz was not on duty, but another officer, Sandra Mills, responded. I showed her the live camera footage and the damaged tires. "Can you make out any identifying features?" she asked, watching the video. "No, they are covering their faces. But look at the build of the smaller one. That is a woman." "Maybe. Hard to say for sure. But this is good evidence. I will take a copy of the footage. This is criminal mischief, possibly escalating to a hate crime if we can prove it is targeted harassment." The next morning, I filed an insurance claim for the tires and sent a copy of the footage to Gerald. I also posted about it on the Meadowbrook Hills community Facebook page, which I rarely used but knew Patricia monitored. "Someone vandalized my trailer last night," I wrote. "Second incident in a month. Police are investigating. If anyone saw anything or has any information, please contact me or the Buffalo PD." The post got a lot of responses. Most people were sympathetic and outraged that someone would do this. A few suggested I just get rid of the trailer to avoid more problems, which made me even more determined to keep it. Then I got a private message from a neighbor I barely knew, a woman named Kelly Foster who lived 3 houses down. "Quincy, I do not want to start drama, but I saw Patricia and her daughter walking around the neighborhood late last night, like really late after midnight. I thought it was weird at the time. Not saying they did anything, but with the timing and everything, I thought you should know." I forwarded the message to Officer Mills. She called me an hour later. "Mr. Xavier, based on the footage and this tip, we would like to question Mrs. Winters and her daughter. Would you be willing to press charges if we find evidence linking them to the vandalism?" "Absolutely." "Okay. We will be in touch." The next day, I learned through the neighborhood grapevine that police had visited Patricia's house. Apparently, it had not gone well. Patricia had refused to let them speak to her daughter without an attorney present, and had threatened to sue the police department for harassment. But here is where things got interesting. Patricia's daughter, whose name was Bethany, was 19 years old and home from college for spring break. 2 days after the police visit, I got an unexpected knock on my door. It was Bethany, and she looked terrified. "Mr. Xavier, can I talk to you?" she asked, her voice shaking. I stepped out onto the porch. "What is going on, Bethany?" My mom, she made me help her. I did not want to, but she said we had to teach you a lesson. She said you were ruining the neighborhood and that someone had to stand up to you. "Are you talking about the vandalism?" Bethany nodded, tears streaming down her face. "Both times. The spray paint and the tires. It was her idea. I just went along because she is my mom and she kept saying it was the right thing to do. But I feel sick about it. I cannot sleep. I cannot eat. This is not who I am. Bethany, you need to tell the police this." "I know. That is why I am here. I am going to the police station after this. I just wanted to apologize to you first. What we did was wrong. I am so sorry." I looked at this kid, clearly racked with guilt, and felt a mix of anger and sympathy. "I appreciate you coming forward. That takes courage. Will you press charges against me?" I thought about it. "That is not really my decision. But I will tell the police that you cooperated and showed remorse. That should count for something." Bethany nodded and left. An hour later, Officer Mills called me. "Mr. Xavier, Bethany Winters just came in with her father and gave a full confession. She implicated her mother as the instigator of both incidents. We are going to arrest Patricia Winters for criminal mischief and for involving a minor in criminal activity." "What about Bethany?" "Given that she is 19 and came forward voluntarily, the DA will probably offer her a plea deal. Community service, restitution, probation. Her cooperation against her mother will work in her favor." That evening, I watched from my living room window as 2 police cars pulled up to Patricia's house. Officers knocked on the door, and after a few minutes, Patricia emerged. Even from across the street, I could see her face was red with anger. They handcuffed her and put her in the back of a patrol car while her husband stood in the doorway, looking shell-shocked. The neighborhood Facebook page exploded. People could not believe that Patricia, the president of the HOA, had been arrested for vandalizing my property. Some defended her, saying the stress of dealing with my trailer must have pushed her over the edge. Others were appalled and called for her resignation from the board. The HOA held an emergency meeting 3 days later. I attended, along with what seemed like half the neighborhood. The remaining board members, clearly uncomfortable, opened the meeting by acknowledging Patricia's arrest and announcing that she had resigned her position effective immediately. Thomas Garrett, now acting president, addressed the room. "We want to assure everyone that the board does not condone Mrs. Winters' actions. She acted alone, and her behavior does not reflect the values of this organization." Someone from the back shouted, "But she was enforcing HOA policy." "She was doing what you all voted to do." Thomas looked flustered. "We voted to enforce the covenant through proper legal channels. We never authorized or encouraged vandalism or harassment." Marcus Flynn stood up. "I think we need to take a hard look at our covenants. This whole situation got out of control because the HOA tried to enforce a rule that conflicted with state law. Maybe it is time to update our covenants to reflect reality." There was murmuring of agreement from several people. Robert Chen spoke up. "I actually agree. I abstained from the vote to fine Mr. Xavier because I had concerns about whether we were on solid legal ground. The judge's ruling proved those concerns were valid. We need to amend Section 12.4 to clarify that it does not apply to properly registered highway vehicles." The discussion went on for over an hour. In the end, the board voted unanimously to form a committee to review and propose amendments to the covenants. They also voted to formally drop any remaining disputes with me and to apologize for the harassment. Thomas approached me after the meeting. "Quincy, On behalf of the board, I want to apologize. This should never have escalated the way it did. Patricia became fixated on your trailer and we should have reined her in sooner." I shook his hand. "I appreciate that, Thomas. I never wanted any of this. I just wanted to park my trailer in my driveway." "Understood. And for what it is worth, I think your business is great. My brother used your company last year for his landscaping, and he was really happy with the work." Over the following weeks, things slowly returned to normal. Patricia was charged with 2 counts of criminal mischief and 1 count of contributing to the delinquency of a minor, which apparently applied even though Bethany was 19, because Patricia had used her parental influence to coerce Bethany into illegal activity. Patricia hired a defense attorney and pleaded not guilty, but the evidence was overwhelming. Bethany took a plea deal as expected. She was sentenced to 100 hours of community service, ordered to pay restitution for the damage to my trailer, and given 2 years of probation. Her father paid the restitution in full within a week, and Bethany wrote me a heartfelt letter apologizing again for her actions. Patricia's case went to trial in June. I had to testify, describing the escalating harassment and presenting the security footage. The jury deliberated for less than 3 hours before finding her guilty on all counts. The judge, a stern woman named Teresa Gonzalez, was not sympathetic. "Mrs. Winters, you held a position of authority in your community. Rather than using that position responsibly, you allowed a personal vendetta to drive you to criminal behavior. You vandalized your neighbor's property, involved your daughter in that criminal activity, and showed no remorse throughout this process. I am sentencing you to 6 months in the county jail, suspended after 90 days with good behavior, 3 years of probation, and restitution for all damages caused to Mr. Xavier's property and his legal fees related to your criminal actions." Patricia was led out of the courtroom in handcuffs. I felt no satisfaction in seeing it. The whole thing had been such a waste. If she had just accepted the judge's ruling about the trailer, none of this would have happened. The HOA covenant amendments were approved by a vote of the membership in July. The new language explicitly stated that Section 12.4 did not apply to properly registered and licensed highway vehicles, regardless of their commercial use. The vote was 78% in favor, 12% against, and 10% abstaining. By August, life in Meadowbrook Hills had settled into a new normal. A new HOA board was elected, with Marcus Flynn as president. He ran on a platform of common-sense governance and limiting the HOA's reach to genuinely important community issues like maintaining common areas and ensuring safety. My landscaping business continued to thrive. The snow dump trailer that had caused so much trouble proved to be one of the best investments I had ever made. It paid for itself within the first year and made my snow removal operations far more efficient. I occasionally saw Patricia's husband around the neighborhood. He always looked uncomfortable and avoided eye contact. Patricia herself spent 90 days in jail, was released in October, and moved out of Meadowbrook Hills shortly after. I heard through the grapevine that she and her husband were getting divorced, and that she had moved to Rochester to be near her sister. Bethany sent me a Christmas card that year. In it, she thanked me for not pushing for harsher punishment against her, and told me she had learned a valuable lesson about standing up to authority figures, even parents, when they are asking you to do something wrong. She was back in school, studying social work and doing well. As for me, I still park my snow dump trailer in my driveway. It sits there right now as I write this, gleaming in the afternoon sun. Every time I look at it, I am reminded of an important lesson. Standing up for your rights is not easy and it is not always cheap, but it is worth it. not just for yourself, but for everyone who comes after you. The legal fees were eventually fully reimbursed, both from the HOA and from Patricia's restitution payments. The emotional toll was harder to calculate, but my family came through it stronger. Emma and James learned that their dad would fight for what was right, even when it was difficult. Rachel learned that I would listen to her concerns but ultimately had to follow my principles. The neighborhood learned something too. The HOA covenant amendments that came out of this mess made life better for everyone. People could park work vehicles in their driveways as long as they were properly registered. The height restrictions on grass were relaxed. The rules about Christmas decorations were simplified. The whole community became a little less uptight and a lot more livable. Marcus turned out to be an excellent HOA president. Under his leadership, the board focused on things that actually mattered, like organizing neighborhood events, maintaining the community center, and keeping the common areas looking nice. Violations were handled with common sense rather than rigid enforcement of every minor rule. I ran into Marcus at the hardware store one Saturday in December, almost exactly a year after the whole ordeal had begun. We were both buying ice melt for the coming snow. "How is the trailer working out?" he asked with a grin. "Best purchase I ever made," I replied. "Well, aside from my house." "In my house," he corrected with a laugh. "Fair point." We talked for a few more minutes about the upcoming winter season and the neighborhood Christmas party the HOA was planning. As we parted ways, Marcus said something that stuck with me. "You know, Quincy, what you did took guts. A lot of people would have just moved the trailer to avoid the hassle, but you stood your ground and it made this place better for everyone. So thank you." I thought about that as I drove home. Had it really made things better? The answer, I realized, was yes. Not because I had won a legal fight or because Patricia had been punished for her crimes, but because the community had been forced to examine its rules and its values. We had all learned that covenants and regulations are supposed to serve the people, not the other way around. That winter was busy for my business. The snow dump trailer was in constant use, hauling load after load of snow from parking lots and driveways all over Buffalo. Every time I pulled into my driveway at the end of a long day, I felt a sense of satisfaction. This was my property, my business, my livelihood, and no HOA could take that away from me. The legal precedent from my case actually had ripple effects beyond Meadowbrook Hills. Gerald told me that other attorneys in the area were citing Judge Morrison's ruling in similar disputes. HOAs across New York were being forced to reconsider overly restrictive covenants that conflicted with state vehicle registration laws. In a small way, my fight had contributed to a broader shift toward more reasonable governance in planned communities. Of course, not everyone was happy about it. I still got the occasional dirty look from residents who thought I had destroyed the neighborhood's character. But most people were fine with it. Some even thanked me for standing up to what they saw as HOA overreach. The damages I had suffered, both the vandalism and the stress of the legal battle, were significant. But the restitution payments covered the financial costs, and time healed the emotional wounds. My family was closer than ever. My business was thriving. And I had the satisfaction of knowing I had fought for something important and won. Looking back, I could have handled some things differently. Maybe I could have been more diplomatic in my early interactions with Patricia. Maybe I could have tried harder to find a compromise. But ultimately, I do not think it would have mattered. Patricia was determined to enforce what she saw as her authority, and she was not going to be swayed by reason or law. The confrontation was probably inevitable. The important thing is how it ended. Justice was served. The law was upheld. The community was improved. And I learned that sometimes the hardest battles are the ones fought right in your own neighborhood, against people you see every day. But those battles are often the most important ones, because they define the kind of community you want to live in. As spring approached and the snow began to melt, I started preparing for the landscaping season. The trailer that had caused so much controversy was now just another tool in my arsenal, parked in my driveway alongside my truck and other equipment. Kids in the neighborhood would sometimes stop to look at it, admiring the hydraulic lift mechanism. I would explain how it worked, and they would watch in awe as I demonstrated raising and lowering the bed. One day, a little boy from down the street, maybe 7 years old, asked me, "Mister, why is your trailer so cool?" I smiled. "Because it helps me do my job and take care of my family, and because I have the right to keep it here, no matter what anyone says." He nodded seriously, like I had just imparted great wisdom, and ran off to play with his friends. That moment, more than anything else, summed up what the whole fight had been about. It was not really about a trailer or HOA rules or legal precedents. It was about the fundamental right to live your life, run your business, and use your property in a way that harmed no one but served your legitimate needs. It was about refusing to let arbitrary authority dictate the terms of your existence. The Meadowbrook Hills community continued to evolve. The new HOA board under Marcus's leadership implemented several other reforms. They established a grievance process that allowed residents to challenge violations before fines were assessed. They created an ombudsman position to mediate disputes between the board and residents. They even amended the rules to allow vegetable gardens in front yards, something the old board would never have permitted. These changes created a more harmonious community. Compliance with reasonable rules actually went up because people felt the rules were fair and sensibly enforced. The few truly problematic situations, like a house that was genuinely falling into disrepair, or a yard that became overgrown with weeds, were handled with offers of assistance rather than immediate fines. I found myself more involved in community affairs than I had been before. I joined the Architecture Review Committee, helping to evaluate requests for home improvements and additions. My experience with the trailer dispute gave me a perspective that proved valuable. I always asked whether a proposed restriction served a legitimate purpose or was just arbitrary control for its own sake. The business continued to grow. By the second year after the dispute, I had 3 trucks, 2 trailers, and 4 employees. The snow dump trailer that had started it all was joined by a second one. Both were parked in my driveway during the off-season, and no one said a word. Well, no one except for old Mrs. Henderson, 2 houses down, who told me she thought they looked very professional and made her feel good about the neighborhood's work ethic. Rachel sometimes joked that I had become a minor celebrity in local HOA circles. I was invited to speak at a seminar for homeowners dealing with HOA disputes. I told my story and offered advice. Document everything, know your rights, stand firm on matters of principle, and always try to find reasonable solutions before resorting to legal action. One person in the audience asked, "But what if the HOA is truly unreasonable? What if they will not listen to reason?" I thought of Patricia, of her rigid determination to enforce her vision regardless of law or common sense. "Then you have to be prepared to fight," I said. "Not everyone has the resources to hire a lawyer and go to court. But if you are in the right and you can afford to stand your ground, sometimes you have to, not just for yourself, but for everyone else who might face the same unreasonable demands in the future." The years passed. Emma and James grew up in a neighborhood that had learned important lessons about governance and community. They saw their father stand up for his rights and win. They also saw him treat Patricia's husband and daughter with respect and compassion, refusing to gloat or seek revenge. I hope those lessons served them well in their own lives. The landscaping business eventually grew large enough that I rented commercial space for equipment storage. But I kept one snow dump trailer at home, parked in my driveway, partly because it was convenient and partly because it was a symbol of the right to live free from arbitrary restrictions, to use your property as you see fit, and to stand up to authority when it oversteps its bounds. Patricia's name faded from neighborhood conversation. New families moved in, unaware of the drama that had once consumed Meadowbrook Hills. The HOA functioned smoothly under reasonable leadership. Property values continued to rise, proving that allowing properly registered vehicles in driveways did not, in fact, destroy the community's appeal. I sometimes wondered what Patricia was doing in Rochester. Had she learned anything from the experience? Had she found peace? I hoped so, though I doubted it. Some people are so invested in control and authority that they never learn to let go. But that was not my problem anymore. My problem was running a successful business, raising my kids, and being a good neighbor. The snow dump trailer in my driveway was just a tool for the first goal and a reminder of the principles underlying the other two. On the 5-year anniversary of Judge Morrison's ruling, the local newspaper ran a story about HOA reform in the Buffalo area. My case was mentioned as a turning point that had led to greater awareness of homeowners' rights and more reasonable covenant enforcement. The reporter interviewed me for the story. "You have any regrets about how things played out?" she asked. I thought carefully before answering. "I regret that it had to go as far as it did. I regret that Patricia felt so threatened by a trailer that she committed crimes. I regret the stress it put on my family, but I do not regret standing up for my rights, and I am glad that some good came out of it for other homeowners dealing with similar issues." "Would you do it again?" "In a heartbeat," I said without hesitation. The story ran on the front page of the local section. I got calls and emails from people across Western New York sharing their own HOA horror stories. Some asked for advice. Some just wanted to vent. I listened and offered what wisdom I could, always emphasizing the importance of knowing your rights and standing firm when those rights were violated. My snow dump trailer sits in my driveway today as I finish writing this. It has been nearly 6 years since Patricia first marched across the street to confront me about it. The trailer is a little older now, showing some wear from years of hard use. But it is still DOT registered, still licensed for highway use, and still perfectly legal to park on my own property. And every time I look at it, I remember that rights mean nothing if you are not willing to defend them. That communities thrive when governed by reason rather than rigidity. And that sometimes, the most important stands you take are the ones made right in your own driveway, in defense of principles that might seem small, but are actually fundamental to how we live together in a free society. The fight over my snow dump trailer changed my life, changed my neighborhood, and in a small way, changed how HOAs operate in New York. It started with a simple confrontation and ended with criminal convictions, legal precedent, and community reform. Through it all, the trailer remained what it had always been: a properly registered vehicle, parked legally on private property, serving a legitimate business purpose. That was all it ever needed to be. And that, ultimately, is what I fought for and won the right to maintain. Not just for me, but for every homeowner who refuses to let arbitrary authority override common sense and the law.